Kinsey, Luger, and Villarreal on behalf of the plaintiff Bookington Contracting Company.
Good morning.
Morning, Your Honor.
Good morning, Your Honor. Jason Thomas, and I believe my partner Claudio Yanatelli is with us by phone on behalf of Fiat Incorporated and Mr. and Mrs. Hooper.
Good morning, Your Honor. This is Claudio Yanatelli.
Good morning. Appreciate everyone being here. We have this time set for trial setting conference. I did receive your joint status report. Thank you for submitting that. Looks like you still haven't done a some sort of alternative dispute resolution. I know you've got some pending motions. I'm of the matter or of the mind that we reset this joint status report to sometime down the road after you are able to have your settlement conference. Any objection to doing that?
No, Your Honor.
No, Your Honor. That would be our preference.
Yeah, when do you think a good time to have that would be, the trial setting conference? In other words, how much time do you need to complete your settlement conference, which I presume is sort of hinging on the current motions for summary judgment?
Your Honor, I would be fine with setting the settlement conference whenever we can get, reasonably into that posture. Obviously there's some merit and advantage to waiting until the motions for summary judgment are done, but that's not necessarily always the case. If we have success in the settlement conference, then we have success globally. So with that said, my client is flexible on either having that set for the near future, regardless of whether it falls in the calendar relative to the court hearing the motion for summary judgment and the cross. But obviously I know that the defendant would prefer to wait until the motions are resolved.
Well, I'm going to let the two of you kind of figure out the timing of when exactly you want to make that request. At this point, you have to file a joint certificate of readiness, and our ADR folks will pick that up and get you set on whatever timeline they have. So just in theory, if you were to file one today, I imagine that they would get that picked up. It would probably be assigned here in a couple of weeks, and then you would have, I think it's 60 days or something like that to actually make that happen, which means you're not really guaranteed to have a settlement conference until at least mid-November, giving you a little bit of wiggle room there, sort of depending on when you actually want to file that statement. I would think we wouldn't want to come back here until probably mid-December. Does that seem reasonable?
Yes, Your Honor.
It does.
Okay. What do we have for a 15-minute trial setting conference sometime mid-December? December 14th, 8:45. How does that work for everybody?
That works.
It's good with defendant, Your Honor.
Great. So we're going to reset this trial setting conference for Monday, December 14th, 8:45 in the morning. Please do get me an updated joint status report at that time. Obviously, I have some basics here from you that will be helpful, but if I knew what the current status was when we get there, that'd be better. 1 week prior, just as usual. Anything we can discuss before we go?
Yeah,
that's all for
Claudio. I'm sorry.
Go ahead, counsel.
Yeah, I was going to say, would it make sense to consider whether we would schedule oral argument on the summary judgments, and if so, to do that so now, or whether the court prefers to wait till when that's fully briefed?
I'll wait until that's fully briefed. I don't always do oral argument. It just kind of depends on the situation. And I'd like to take a look at the motions and responses and all of that before I make that decision.
Understood.
All right. Appreciate everyone's time. Have a good rest of your day.
Thank you, Your
Thank
Honor.
you, Your Honor.
Bye.
Morning, everyone.
Morning, Your Honor. So
I'm happy to get started early. I realize 10 minutes early is quite early, but if everyone's ready to go,
Yeah.
or if you need a few minutes just to kind of get your
Your Honor, I
bearings.
think we just need 1 minute to figure out our Wi-Fi scenario.
Okay, yeah. Tell me when you're ready.
So you
And
you can just do the power.
And it teaches you, like, you know, when you're at like a Starbucks or something, it takes you like a page where you have to
Sign
agree.
in or agree
Yeah,
to their
you just have
terms.
to agree.
Okay.
I don't know, it's private, so just I don't know what that means.
Such is life.
Mhm.
You got an email, but like it doesn't really have any instructions for like how to do anything. God, I think we are ready.
Let me log into Case Center here.
Sure.
Just a moment.
I just have a couple of house cleaning things I was hoping to bring up to the court before we start.
Yeah.
Just like a computer system. Efficient structure, just in case I'm like panicking. Mhm. And then that's yours, yeah.
It showed
And
you
it's
what it was
all in
about, you
offices.
and I forwarded it to you.
Yeah. I don't think claims counsel.
Oh, no. So this is like all the evidence that the court has, and I'm pretty sure once I didn't put in the directions, but it's kind of self-explanatory. But I think once I hit print that, you'll be able to see it. It'll come up like. I hope. The case center, I think you just hit review and then it will come up for everybody.
Louisa has
We're
it
about to-
figured out.
I'm glad you guys have to do it.
Oh, but just that, video.
Okay.
Wasn't working on here.
For either of ours.
Or uploader ours. She's got it on her.
Okay. Okay, I have everything on my computer too, if there's anything that doesn't work in the middle of it. I downloaded everything because I'm afraid.
All right, you ready to get started?
Yes, sir.
All right, good morning, everyone. This is CV 2025-020361 McCluskey versus State of Arizona. Council's due appearances, please.
Samantha Kaplinger on behalf of Joshua McCluskey, who is also present.
Good morning.
Michael Baskin and Angela Schultz on behalf of the Department of Public Safety.
Good morning.
Good morning.
All right, we have this time set for our trial de novo. Council, I know you had a couple of housekeeping questions. I have my standard first question, which is, does it make any sense for us to talk about resolution?
Your Honor, I don't think so. I would never tell the court I won't talk about resolution if the court wants, especially if the court's willing to do it, but I don't think it'd be a good use of anyone's time at this point, frankly.
Council?
I agree.
Okay. All right. You had some questions?
Okay, I guess first, Your Honor, we're sorry. This is the first time using case management. I'm not sure how smooth it's gonna go, but
That's
you
fine.
can make sure we'll do our best. Secondly, we have a number of joint exhibits, 1 through 39, that I don't know if the court is amenable to just admitting in batch up front, or you'd rather do it one by one as we go.
I'd rather do it one by one, only because I'd like to know what it is,
Okay.
and doing that sort of allows me to register its sort of place in the evidentiary universe.
And then just the second question, once an exhibit's admitted without a jury, do you want us to ask your permission to publish it each time?
Honestly, once it's admitted, I'm probably staring at it on the screen by then already, so.
Understood.
Anything else that we need to address?
No, thank you.
Okay. I think I mentioned this last week. I'm still getting used to these things here, and they're still messing with me, which I have realized means that my handwriting, which is atrocious to begin with, is either completely illegible or miraculously very nice and neat. And I don't really want to worry too much about which one of those is going to be the case. So I'm probably going to buck my usual trend and actually take notes on my computer. So if you see me typing away, that's what's going on. I know sometimes that can be distracting, people thinking I'm doing emails or buying something on eBay or something. No, I'm doing the only thing I can think of right now to make sure that I have notes that work for me. So hopefully that's not too distracting. If it is, we can chat about it. Okay. So we have 3 days set aside here. And I want to talk a little bit about time limits before we get going. I know that you had indicated that if we were to get started and take short lunches, we may actually be done early, and that's promising, but I don't want it to risk the possibility that things take a lot longer and we start going overtime. I don't want that to be the case. So I am going to set a time limit, keep times, just so that everybody is aware. I need to think a little bit about it, and I probably should have done this beforehand because it's usually, I think, 2 hours and 45 minutes, if I remember right, per side per day. When we have jurors here, it might be a little bit more. Are we planning on going until 5 today? If we, or did you want to get done? I don't know how much we're trying to press to get done in 2 days.
Preliminary on the witnesses, which I should have brought up. We have one of the main department witnesses is not available till tomorrow. I think we mentioned that at the final trial management. So I have 2 witnesses kind of on standby in case we go at the speed we expect. But I still think even with them, we might finish a tad early before 5, if that's okay with the court. And then tomorrow we might be very close to 5 or at 5 because of the number of witnesses coming from out of town.
Okay. Do the math here. Yeah, why don't we stick with 2 hours and 45 minutes per day at 3 days? That gets you what, 8 hours and 15 minutes per side. All right. Everybody good with that?
Yep.
Yeah.
Okay. All right. Anything else you need to address before we get started?
Not from defendant, Your Honor.
Not from the plaintiff either.
All right. Are you doing opening statements or are we just going straight into evidence?
I think we were planning on doing opening statements.
All right. Whenever you're ready, counsel.
All right. Thank you, Your Honor. Before getting to why we are here and summarizing the facts, I think it is appropriate at the outset to emphasize that the dispositive facts in this case are largely undisputed. Mr. McCluskey is on camera issuing a citation for which he admitted he had no justification, no reasonable suspicion to issue. This is the Cobbs citation. The evidence will show that McCluskey knew he had no lawful factual basis for the Cobbs ticket. Indeed, he admitted to DPS that he had zero reasonable suspicion or probable cause to write it. The evidence will show that he admitted it was a dishonest act under DPS policy, under the dictionary definition of dishonesty, and under his own understanding of dishonesty. The evidence will show that he then submitted that citation to the court as an official government record, despite admittedly having no reasonable suspicion to issue it. Excuse me, Your Honor. The